Okay, so I'm going to give you an overview on your rights at work. And this is the Cancer Legal Resource Center presenting to you. We're a program of the Disability Rights Legal Center, and this is the Disability Rights Legal Center's mission. We champion the rights of individuals through litigation. The Cancer Legal Resource Center, however, is based on the educational model. We don't give legal advice or represent clients directly. That is yet, due to limited funding and availability. Our goal instead is to provide you with legal resources and information to help you understand your rights. So we want to empower individuals with knowledge of their rights so that they are not negatively impacted. And that's part of the reason why we do webinars like this, to educate you, and so that you might be able to educate someone else on their rights and not have to be negatively impacted. We are a free national resource organization. If you want to get in touch with us, the clrcintake.org is the best way to fill out a questionnaire, to have us do some research and get back to you with information and resources. If you don't have access to the internet or are unable to ask someone for help, like a social worker or family member, feel free to give us a call and leave a message, and one of our volunteers can give you a call back and complete the intake with you. But the online intake is the best way to get in touch with us. So if something I go over here in this presentation today brings up a question you have about a specific situation at your job or at someone you know, place of employment, fill out an intake online and give us your information so that we can get back to you with customized resources and information. The information that we provide is free, although on our intake form there is a section to fill out your income, and that is only so that we can match you with the right resources. If someone's not going to be qualified for a legal aid, we won't provide you with a referral to a legal aid. So for reasons like that, we want to make sure that we gather all your information, and then we can get back to you with specific answers to your questions. So that's the online intake. All right, so cancer-related legal issues. When we say that we're the Cancer Legal Resource Center, people sometimes wonder, what are the cancer-related legal issues? The CLRC handles issues such as health insurance, employment, life insurance, government benefits, all the topics you see here on this screen. And today I'm going to focus on employment law, because there's a lot to know about employment law. And if you have questions about any of these topics that you see here on the screen, that's exactly the kind of thing we want you to contact us about. The disability insurance, that's a huge topic. Some government benefits, estate planning, planning for your future, wills and trusts, that sort of thing. Health insurance topics, that's another big topic. So if you have questions about those type of things, I'm not going to cover that today, but feel free to fill out an online intake with your questions about whatever information that you have. Okay, then I'll go over today's presentation, your rights at work. This is what I'm going to go over in this presentation today. We'll focus on different subjects like medical leave, your right to take time off of work, anti-discrimination laws, your right to be free from discrimination in the workplace, and then reasonable accommodations. Of course, you have the right to be free from discrimination, but you also have the right to have a reasonable accommodation in the workplace. When someone receives a cancer diagnosis, often the workplace is the place where they may be legally impacted first. Our jobs provide us with income and health insurance, so it's really important to know your rights in the workplace so that you can protect yourself and have the knowledge of how to ask for what you're legally entitled to. And then I'll explain your rights to take time off work as well as anti-discrimination laws. So these are some of the laws that impact people at work. I'll go over your rights to take medical leave, whether you have a job currently or you're wondering about going back to work. And then I'll also talk about anti-discrimination laws that apply to an employee as well as an interviewee. And I'll go over what reasonable accommodations are under federal and state anti-discrimination laws. So I like to use real-life examples. These are made-up scenarios of typical callers and their situations that they face. So let's start with John. He'll be our first case study as I explain John's right to take time off of work. So John is a full-time bank manager, so he's a full-time employee. He works at a place with 60 employees, and he's been there for 8 months. He just found out that he needs to have a surgery, which means that he's going to have to take some time off. I want to talk about what are John's options. FMLA. This law maybe you've heard of. It's called the Family Medical Leave Act, otherwise known as FMLA. If John meets the requirements for FMLA, he can take leave time from his job and not worry about whether he'll still have a job when he gets back. So FMLA is 12 weeks of unpaid job and health benefit protected leave per year to take care of yourself or a covered family member if you work for a covered employer and you meet the eligibility requirements. So I'll go over each of those bullet points in the following slide. So how are you a covered employee eligible for FMLA? You have to have worked for 12 months and at least 1,250 hours in the last year. So I remember FMLA by remembering 12, 12, 12. You get 12 weeks of unpaid job protected leave if you've worked there for 12 months and you've worked 1,250 hours in the last year. The 12 months doesn't have to have been all at once. That helps cover seasonal employees. So if you've worked a total of 12 months at the place of employment, then you would be eligible for FMLA if you've worked 1,250 hours in the last year. That averages to about 24 or 25 hours a week, so that part-time employees can also be eligible for FMLA as well. But you have to work for a covered employer. So even if you've worked 12 months, you've worked 1,250 hours, you can't take 12 weeks of leave time unless your employer is either a government employer or a private employer with 50 or more employees within a 75-mile radius. So if there are 25 employees at one place of employment, but within 75-mile radius, there's another branch that has another 25 employees, then that would qualify as an employer who has to provide FMLA. So the rules are that you have to be a qualified employee and you have to work for a qualified employer. And then you can take time off to take care of yourself, of course, or you can take FMLA to take care of a covered family member. It's pretty narrow. It's either parents, children, or your spouse. These are the covered individuals that allow you to take FMLA leave. The 12 weeks of FMLA can either be taken all at once or it can be taken intermittently. It doesn't make sense for everyone to take 12 weeks off in a row. That's about 3 months. So if someone's going to have surgery and they need a few weeks to recover from that, and then they're going to have to later take some more time off for a second surgery, you know, it might make sense to take part of the FMLA that one time and part of it the second time. Or if you're going to be needing treatment a few days at a time, you can take it intermittently. Now, the 12-month period can be calculated either from January to December. So some employers say you can take FMLA 12 weeks from January to December. Oh, you've already taken your 12 weeks this year in 2017. Or it can be any 12-month fixed period. So some employers calculate their annual eligibility from June to June, or different times of the year. No matter how the employer sets up the rules for when the FMLA calendar starts, they have to do it the same for all employees. So regardless of which system your employer selects, they can't say, oh, for you, it's January through December, but for the other employee, it's June through June. So regardless, they have to apply it the same way to all employees. During FMLA, one thing to note is that the employer can require you to take your paid vacation or sick time. So sometimes people are surprised by that, but they can require you to take your paid vacation or sick time. And meaning, like, if you don't want to be paid and you want to take that time off, your employer can say, sorry, we're going to pay you your vacation or sick pay during that time. Or you can elect to have that. Of course, not everybody has a giant stack of money in their bank account, and some people want to be paid during their FMLA leave. FMLA is unpaid but job protected leave. So if you want to be paid during that time, you can elect to take your vacation or sick pay during your FMLA. And you get one 12-week period of leave per year. You can't get FMLA multiple times. So if you're sick and you take FMLA and then a family member gets sick later on, you can't take a second FMLA in the same 12-month period. So you get one set of 12 weeks. 12 weeks is, there's no exceptions to that. I'm going to talk a little bit more about how to extend your FMLA in another slide, but I'll just leave it at that. The only exception to this would be if a person is taking leave to care for a covered service member with a serious injury or illness, then that would be the one exception. But it's 12 weeks of FMLA. And because it is job and benefit protected leave, your job and benefits have to be restored when you return from FMLA. An employee has to be restored to his or her original job or to an equivalent job with equivalent pay, benefits, and other terms and conditions of employment. That is, you can't be punished for taking FMLA and be put to work in a different position that is nothing like your original position. So after you get back from a 12-week leave, you get any employment benefits that you were entitled to before you're using FMLA. So if you can't be punished for taking FMLA leave. If you're unable to return from FMLA, then the employer is not required to reinstate you. If you've used your 12 weeks and you can't come back after that 12 weeks, the employer doesn't have to wait for you to come back and hold your job open. That's what the 12-week rule is. So let's go back to John, our case study. John's a full-time employee. He works at a place with 60 employees at his branch, and he's been there 8 months. So think about the rules that you just learned about FMLA. Can John take FMLA? The answer is no. We don't have more information about whether he's worked more than 8 months. All we know is that he's worked 8 months. Maybe he was working for 12 months, or maybe he was working for 4 months at some point before. But since we don't know that, we'll assume that he's only worked 8 months total at his workplace. And remember, you have to be at your job for a total of 12 months. But there are 60 employees at his branch, so does his employer have to provide FMLA to employees? The answer would be yes. And since he's full-time, we probably don't have to work to calculate the 1,250 hours. So if he had worked for 12 months, he could take FMLA leave. But the answer is no, he can't take FMLA if he hasn't worked the 12 months. Okay, now how do you go about requesting FMLA? What's the protocol for making that request? If you request job protected leave under the FMLA, you might need to provide medical certification to show that you have a qualifying medical condition. You don't have to include your cancer diagnosis specifically, as long as the documentation establishes a serious health condition sufficient to support the need for FMLA leave. I'll talk a little bit about medical certification later on in the presentation as well, and in the sense that it covers both FMLA and ADA. You have to provide a certification to show your boss that you need FMLA. But for now, I'll just let you know you do have to prove that you have a condition that requires medical leave, and they can deny you leave if you don't provide the appropriate medical certification. So I mentioned this before, and I guess I jumped ahead, but you can be asked to take your vacation or sick pay while you're on FMLA, or you can choose to. When that is if the leave is for your own serious health condition. If you're taking FMLA to care for a family member, they can't make you take your sick pay. So if you need a source of income while you're off, this is one option. And then okay, and if you're not qualified for FMLA, are you out of luck? Not necessarily. If you don't have enough time off, if 12 weeks isn't enough time off for your condition, and you know you need to be out a little bit longer, two pieces of information that might help. Number one, check your employee handbook. Some employers have a really generous leave policy. And some employers, even though there aren't 50 or more employees and they don't have to abide by FMLA, some employers actually provide 12 weeks of medical leave if an employee has worked for a year. So a lot of employers have a policy on medical leave. So be sure to check your employee handbook. That's the thing that we file away in our emails when we first get hired, and we don't look at until we need something in there. So check that handbook, see if there's a medical leave policy. And then another option is to, if 12 weeks wasn't enough, and you still need to take a little bit more time off, or if you don't qualify for FMLA at all, but you have a disability under the ADA, which I'll explain in a little bit, you can ask for leave time as a reasonable accommodation. I'll explain exactly what that is in a later slide, but essentially, if you qualify for ADA protection, you're allowed to ask for accommodations to help you enjoy equal opportunity employment. So a reasonable accommodation could, in some cases, be taking time off under the ADA. So I'll explain exactly how that works, but it might be a reasonable accommodation to say to your boss that you need an extra week off before you can come back to work, or to ask about taking leave as a way to accommodate a disability under the ADA for a person who isn't qualified for FMLA in the first place. And we have some handouts that explain this. These webinars and presentations are generally just an overview to help you understand, A, that these laws exist and that there are some nuanced rules in these laws. But we're going to go over all this stuff really quickly, and if you need more clarification, our website has a ton of resources and handouts that help explain some of these rules in case this is a lot of information to digest and you want to go take a look at it and say, what was that other option if I don't have enough time off of work and I need to ask for another week off? So just a heads up. Okay, so I'm not going to go over all of the rules for teachers specifically here, just in the interest of time, but I do have to let you know that there are certain specific and additional rules if you work for a local education agency. So if you work for a school, you can fill out an intake at clrcintake.org if you have specific follow-up questions about being an employee of a local education agency. But if you're taking leave, if you request FMLA that would have you out of work near the end of the school term, there are specific rules that apply. Like if you're requesting leave within a certain amount of time within the end of the term, certain rules apply. So I'm leaving this link up here. This is a link to the FMLA, the Department of Labor's question and answers about how it applies to the local education agencies. That'll give you a little bit more information. But like I said, you can fill out an intake at clrcintake.org with the specific question that you have on that. So in a nutshell, this is the FMLA. You get 12 weeks of unpaid job and benefit protected leave. So your benefits and job have to be restored at the end of the 12-week period. If you've worked 12 months at your job, 1,250 hours in the last year, and if your employer is a qualified employer of 50 or more employees or is a government agency. And if you're not qualified for FMLA, you can ask for time off as a reasonable accommodation under the ADA, and you can check your employee manual. So that is an overall recap of FMLA. And again, our website has some resources about FMLA and employment in general, and you can consult that, or you can ask us specific questions at clrcintake.org. I will move on then to workplace discrimination, now that hopefully you have an idea of your right to take a medical leave. Just switching gears ever so slightly here. So I mentioned if you can't get FMLA, you can request a reasonable accommodation under the Americans with Disabilities Act. This is going to go over, this is going to be going over that part of it. So I'm going to go over job discrimination protection, and just so that you know, people with disabilities cannot be treated differently in the workplace, even in the interview process. And the workplace anti-discrimination laws apply to all phases of employment, including the applications, hiring and firing. You can't be hired or fired on the basis of a disability. That would be discrimination. You can't be denied leave on the basis of a disability. You have to be given the same opportunities for promotion. The same testing and training has to be provided to a person with disability, and all other terms and conditions of employment have to be provided in an equal way. So I want you to know your rights in the workplace before it's too late. Pass along this information to anyone you think may want to know. It's important to know your rights so that you can exercise them and advocate for yourself and avoid negative consequences, potentially even being fired. Unfortunately, people tend to contact us when it's too late. We provide these educational presentations to members of the community as much as possible with the hopes that people stop losing their jobs when it could have been avoided by asserting your rights under the law. So there are state laws as well. I'm going to go over generally what the state laws may provide, but this presentation will be heavily focused on the Americans with Disabilities Act, and I will move right into that. The ADA, just like FMLA has requirements to working for an employer of a certain size, so does the ADA. The Americans with Disabilities Act, which I'll refer to as the ADA, applies to people who work for employers of 15 or more employees. So your employer has to have a minimum of 15 employees to be covered by the ADA, and to be a covered person under the ADA, you have to be an employee or an interviewee with a qualifying disability, and you have to be a qualified employee. What does that mean? Well, a qualified employee must be able to perform the essential functions of the job. If you need reasonable accommodations to help you perform those essential functions of the job, you're still qualified. Qualified means that you can perform the essential functions of the job with or without reasonable accommodations. If there is no accommodation that would help you do those essential functions of the job, then you would not be a qualified employee. For example, a lawyer with a disability who applies for a carpenter's job, unless they're some secret woodworker, isn't going to be qualified because there's no accommodation that could help the attorney be a carpenter. So that to say, having a disability doesn't entitle you to any job. If you can do the job but need some accommodations to help you do the job, then you'd be a qualified employee. If there's no accommodation that exists to help you do the job, for instance, I certainly wouldn't be able to do a carpenter's job, then I wouldn't be a qualified employee if I were applying for a carpenter job. Okay, and then what exactly is a disability under the ADA? Before I move into this, it's important to know the definition of disability under any area of the law. Under the ADA, of course, I'll explain the definition of disability, but if you're looking for protection under any law or want to know your rights to medical leave under a certain law, you want to first make sure that you know the definition of disability as it applies to that law. So how do you know if you're qualified for ADA protection? The definition of disability under the ADA is a physical or mental impairment that substantially limits a major life activity. Then, what is a physical or mental impairment? That could be a current impairment, that's pretty obvious, a history of having an impairment, or being regarded as having an impairment. And some people who are caregivers qualify for ADA protection, but generally that part of the law was intended to stop discrimination of people who are, say, caregivers of HIV patients or someone with another illness that could be seen by society negatively, and therefore those people need some protection as well. So let me break down the first part of the definition. Physical or mental impairment. The history of an impairment, if someone was diagnosed with cancer and has completed treatment and is applying for a new job, that person is capable of doing their job, but if the employer is treating you differently because of your history with cancer, then you'd be covered as a person with a disability under the ADA. If you are regarded as having an impairment, then you would be qualified for protection under the ADA. That means if your employer knows of your diagnosis and starts to treat you differently, that's what we mean by being regarded as. Sometimes if a person doesn't have hair, that's one way that an employer might make some assumptions. Oh, are you ready to come back to work? It doesn't seem like it. I'm not sure if you could do your job. Then the employer is treating you as though you have a physical or mental impairment. Even though you're still capable of doing your job, you'd be entitled to protection based on that as well. And that physical or mental impairment has to substantially limit a major life activity. These are some major life activities. If you have an impairment that prevents you from being able to do anything to take care of yourself, walking, talking, breathing, eating, bathing, basically any activity of daily living that helps you be able to take care of yourself. If you need help doing any one of these activities, that is, you would have a substantial limitation. And I'll explain what a substantial limitation is. A substantial limitation, as it says, the definition is on the slide, means that you're unable to perform a major life activity in the same way as an average person in society. It's not so cut and dry simple. It's determined on a case-by-case basis based on the nature and severity of the limitation, how long it's expected to last, and how big of an impact it has on a person's daily life. So under the ADA, you have to have a substantial limitation on a major life activity. Cancer can be considered a disability under the ADA, but it's determined on a case-by-case basis. Not everyone with cancer definitely qualifies as having a disability under the ADA, but sometimes even the side effects of treatment can be enough to substantially limit a person's major life activities, thus can be considered a disability. So even after cancer treatment is completed, cancer or the treatment can be considered a disability under the ADA. And cancer is as individual as the person. Not every diagnosis is the same, not every prognosis is the same. So depending on where you are in the course of treatment or recovery, cancer can be considered a disability. It's hard to imagine it wouldn't be, but it's a case-by-case determination. And then let's say you're not qualified under the ADA because you work for a place of less than 15 employees. Well, some states have laws that protect people even if you don't qualify for the ADA. So in California, for example, there's a Fair Employment and Housing Act that protects employees of 5 or more employees. And then in Illinois and Hawaii, these are just a couple states I'm using as examples. If you work for an employer of any size, the employer just has to have 1 employee to have some protection under state law. So the state laws determine whether if you work for a smaller employee than 15, a smaller employer than 15 employees, you might qualify for state anti-discrimination law protection. So that's one key thing to note. And then there are states that include cancer as a disability. The one that I know of for sure, as I mentioned before, California specifically lists that cancer is a disability. So you don't have to determine how severe it impacts the major life activity. Cancer is a disability under state law in California. And as I mentioned in the previous slide, under the ADA, it can be a disability. And so especially know this information if you don't work for an employer of 15 or more employees. And then some states just say you have to have a limitation on a major life activity, not a substantial limitation. So it's a little bit easier to prove that you have a qualifying disability. And these state laws often protect people in the exact same way that the Americans with Disabilities Act would. You can't be discriminated against, you can't be fired for having a disability, and you are entitled to reasonable accommodations, which I'll go over. But yeah, if you work for an employer of less than 15 employees, that's when you would want to fill out an intake with the CLRC, clrcintake.org, and we can look up to see whether you live in a state with a law that has an anti-discrimination law that protects people of less than 15 employees. And then, do you let the cat out of the bag? Do you disclose or not to your employer? People often ask us, should I tell my employer about a disability? Should I tell my employer that I have cancer? Ultimately, the decision is a personal one. It's a decision that you have to make, and whether you choose to disclose is entirely up to you. It may be a different decision if you have a visible disability or a non-visible, an invisible disability. Some people choose to disclose just to be fully transparent and eliminate the element of surprise if they need time off later. So in an interview, you're protected against discrimination in the interview process. And oftentimes people wonder, oh, should I let them know if I have cancer or that I had cancer and there's a potential that it could come back? What do I do? That's where it's personal and you have to decide. The fact is there are laws that protect people against discrimination. So the laws are intended to be so that even if your employer finds out you have a disability, they can't deny hiring you and they can't fire you because you have a disability. That's the law. Practically speaking, people are discriminated against. Although discrimination in the workplace is illegal, the unfortunate reality is that it still happens. So some people choose not to disclose because they know there's a risk that they might not get the job if they tell the employer they have cancer. So consider whether you're going to need a reasonable accommodation to do your job, and whether you might need time off. Those things can help you make your decision. And then there are some resources that I'll include at the end of this presentation on different organizations. Like there's a company called JAN, the Job Accommodation Network, that can help talk to you about reasonable accommodations, and they can talk to you about your situation and perhaps give you some practical advice on whether or not to disclose. The Department of Labor website also offers some things to think about in weighing your decision, but ultimately it is up to you. So the Department of Labor oversees FMLA, so you can visit their website to see whether there's some helpful stuff on there to help you be able to make your decision. Okay, I've been talking about reasonable accommodation a lot. I want to get into that here. What is a reasonable accommodation? If you have a disability and you are a qualified employee under federal or state law, remember we talked about those definitions, you might be entitled to reasonable accommodation. So what is that? It's any change or adjustment in the work environment or in the way things are customarily done that enables an individual with a disability to enjoy equal employment opportunities. And that, again, applies to all terms and conditions of employment. So we typically think of a reasonable accommodation maybe in the physical sense. What might be a reasonable accommodation? The way that I explain that oftentimes is, for example, if you're a cashier and you have to stand all day and you have some fatigue due to a disability, you might ask for a chair or rest breaks. So physical accommodations, if your office is on the second floor and there's no elevator and you have trouble walking, you might ask to be moved to an office on the first floor and switched with another employee if there is one available. Those could be examples of a reasonable accommodation. But accommodations are not always physical. For people with cancer, oftentimes the accommodations in the workplace mean an adjustment in the policies and the way things are usually done. For example, a person with cancer might ask for a flexible schedule or a shortened schedule so that a worker can rest or keep their doctor's appointments. They might ask for the option to work from home for a short time, part-time, or even permanently. Would a cashier be able to work from home? Probably not. But if you have that capability or your office can arrange it, you might want to try for that. You can be reassigned to a vacant position, potentially, or a reasonable accommodation to help you do your job could be an extension of leave time. Can be. So accommodations must be reasonable. That is, if an employer should accommodate unless it's an undue hardship. Employers are not required to redefine the position, create a new position, or eliminate the essential functions. Remember, to be a protected employee under the ADA or state law, you have to be a qualified employee. That means you have to be able to do the essential functions of the job. There are some non-essential functions of every job. Oh, you have to be able to do this or that. For maybe a person who works at a moving company as a mover, maybe lifting 50 pounds is an essential function of that job, depending on the job description. But if you work in an office, maybe lifting 50 pounds is not an essential job function and just something you might need to do from time to time. Those things can be reassigned to another person, as an example. Um, Employers do not have to move another employee from their position to reassign you to that employee's position because it might be better for you. If there's a vacant position, an employer could move you to a vacant position and say, well, that job is probably going to fit you a little bit better to help you be able to stay here as an employee, but they don't have to move another employee from their position and give you their job. Accommodations have to be reasonable, not just for the employer, but they have to be reasonable for the individual. There is no one-size-fits-all accommodation. Oh, everyone with a disability gets a chair to sit in. Well, that doesn't help a person who doesn't need a chair. So you have to work with the employer. As soon as you ask for accommodation in the workplace, that begins the interactive process. The employer has to then begin to work with you to try to come up with some sort of accommodation to help you do your job. The accommodation must be effective. It has to be able to help you do the essential functions of your job. It's individualized for that person in that situation and that employer. So what's reasonable to a 5-person office might not be reasonable for a 100-person office that makes a lot more money. So that cashier who needs a chair to sit in can get a chair or a stool, but doesn't necessarily need to have a reclining chair that massages and is leather and plush. So the accommodation has to be reasonable for both the employee and the employer. Now that you understand what a reasonable accommodation is, you can understand that asking for time off might be a reasonable accommodation. The limit to reasonable accommodation is when it becomes an undue hardship for the employer. It has to be reasonable and not an undue hardship. So an extension of leave could be a reasonable accommodation if, say, you've used 12 weeks of leave time, and you need maybe another week or another couple weeks off, and you say, hey, my doctor said that I'll be all better and back to work in 2 weeks. Depending on the nature of your job, depending on how bad the employer was waiting for you to come back and do that job, or whether there are other people to be able to cover for you, the employer might say, okay, that's fine, that's a reasonable accommodation, we'll grant that to you. Now, if you are an essential party and they really need you, they can't do another week, the 12 weeks without you was just a horrible time and they need to hurry up and hire a replacement for you because production has been halted, maybe for that employer it's not reasonable to grant you some time off. So those are just some things to consider. We have a template on our website that outlines how to ask for a reasonable accommodation. It's like a sample reasonable accommodation request letter. And then, of course, there are some resources, like I mentioned, the Job Accommodation Network that can help you. You let them know what your job is and what your employer does, and they can help you come up with some sort of accommodation. When you ask for an indefinite leave, we've had people say, well, my doctor says they don't know when I can go back to work. Why isn't my job holding my position open? If you ask for an indefinite leave, it's hardly ever going to be granted as a reasonable accommodation. There's some super generous employers out there, don't get me wrong, but in most cases, if your doctor doesn't have a date for you to come back to work and just says, sorry, you have to be out of work, I'm not sure when you can come back, 12 weeks isn't enough, probably another 2 or 3 months isn't going to be enough, but we'll see how you do in 6 months. If you ask your employer to hold your job open for a year, it's probably going to be denied. You know, I'm sure I'm wrong, and some employers, they're great, but you know, we can't mislead you to believe that having your job held open for an indefinite amount of time is going to be granted. So what if your employer says, stay out as long as you want, we'll take care of you, your job will be here, just get well, you know, we miss you and we hope that you do well. Be aware that even when somebody says that, at some point it could become unreasonable for them to hold your job open any longer. People have had employers literally say those words, stay out as long as you want, you'll be fine, your job will be here, and then suddenly someone's hired in their position and and ends up taking over permanently, and they get a notice in the mail that, you know, here's your COBRA eligibility benefits, you're done with your employment here. So that does happen in some cases. So just, you know, be aware of that. And then similarly to FMLA, medical certification can be asked of your employer. They can request a documentation of a disability that allows you to ask for reasonable accommodations. They must keep whatever documentation you give them confidential in a separate medical file. There are certain rules on who an employer can disclose to, like your immediate supervisor. They might just put your supervisor on notice that, hey, this employee is going to be needing a chair, so don't be surprised if there's a chair there. That's it. The employee asking for an accommodation in the workplace, just like the employee asking for FMLA, doesn't need to specify a cancer diagnosis. You just need to give enough information to show that you have a disability and that you have a need for an accommodation in the workplace. So some specific rules. We actually have a handout on our website, cancerlegalresources.org, and that handout explains the differences in what's required as far as medical certification under the ADA and under FMLA, and kind of outlines some of the differences. So a few of the things on there. Under FMLA and the ADA, the employer can actually ask the employee to get a second opinion. But under FMLA, if you're making an FMLA request, the employer can only ask you to get a second opinion if the employer has a reason to doubt the validity of the medical certification. If they're like, this looks suspicious, I don't know, I'm going to ask them to get a second opinion and see if they really need that time off. Under the ADA, the employer can ask the employee to get a second opinion if, again, they don't believe the certification is credible, or if there's a mistake on the certification and the employee hasn't corrected the deficiencies, they can ask you to get a second opinion certifying that you have a disability that requires some reasonable accommodation. But the employer does have to pay all costs associated with getting that second opinion. They can't make you get a second opinion and pay for it. So again, visit our website for a handout that clearly explains the medical certification requirements for both FMLA and ADA. Okay, I'm going to talk a lot about job applicants and their rights under the ADA. So you know that under the ADA, you have to be a qualifying employee and work for a qualifying employer, and you have to have a qualifying disability. The same is true for job applicants. You do have rights under the ADA if you work for an employer, or if you're looking to work for an employer of 15 or more employees. And actually, sometimes that's even one of the things that people with cancer look for in a new job. They make sure that the employer is 15 or more employees, so that they can qualify for protections as a person with a disability and be allowed to have reasonable accommodations. Again, you can ask us about your state law in the state that you live in to find out whether under your state you are a qualified employee for a certain number of, if you work for an employer with a certain number of employees. Anyway, that being said, I want to talk about job applicants. An applicant with a disability, just like all other applicants, must be able to meet the employer's requirements for the job, such as education, training, employment experience, skills, or licenses. An applicant with a disability must be able to perform the essential functions of the job or the fundamental duties, either on their own or with the help of a reasonable accommodation. An employer does not have to hire you if you're unable to perform all the essential functions of the job, even with reasonable accommodation. However, an employer cannot reject you only because the disability prevents you from performing minor duties that are non-essential. So again, that essential functions of the job thing is a major consideration for employees looking for a new job. If you're looking for a new job and have had a history of cancer, you might be wondering things such as, can a job application contain medical history questions? Or what should I tell my prospective employer regarding my cancer diagnosis? You never need to disclose to your employer that you have a medical condition unless you're going to ask for a reasonable accommodation or some sort of medical leave. You're not required to disclose in an interview whether you've taken medical leave in the past or expect to take medical leave in the future. Those are inappropriate questions to ask in an interview. However, if an employee chooses to reveal that he or she has cancer or another disability, the employer might ask if the employee will need an accommodation. The ADA prohibits employers from asking questions that are likely to reveal the existence of a disability before making a job offer. So this website here, the EEOC.gov that I'm covering up, there's a fact sheet about job applicants that really clearly goes over some of the rules, the question and answers. So the ADA kind of splits it up into, for job applicants, the pre-offer period and the post-offer period. Pre-offer, if you're just sitting behind a desk interviewing your potential boss, they cannot ask you questions about your medical conditions or whether you'll need reasonable accommodations on the job. Now, there are different rules for police officers or for someone who is going to be a driver, things like that. So, I'm just talking generally, but you'd have to ask those specific questions based on what type of job you're applying for. So, pre-offer, if the employer has not made you a job offer, they can't ask you questions that are likely to reveal the existence of a disability. That includes written questions and inquiries during interviews. However, after an offer has been extended, but before you begin work, this is called the post-offer period, an employer can ask questions and ask an employee to take a medical exam so long as the employer asks those questions to everyone who's offered the same type of job. Here's like the truck driver. Are you on any medication that would impair your driving? That's the post-offer period. They can't only ask those questions to people who have obvious disabilities. They have to ask the same questions to everyone. So if they don't, that would be discrimination. An employer can ask if you'll need reasonable accommodations on the job, but again, not during the interview, because then it's likely to reveal that you have a disability. Unless it's obvious that the employee has a disability or has voluntarily offered that information, then it could be reasonable for an employer to say, are you going to need an accommodation? It could be a reasonable question to ask if the disability could pose difficulties for an individual performing a specific job task. So they could ask, are you able to perform the essential functions of the job, and how? So here's an example that was actually on the EEOC website. Carl has a severe limp. He uses a cane because of his prosthetic leg. He applies for an assembly line job, which does not require employees to move around, but does require that they stand for long periods of time. The employer asks Carl about his ability to stand and whether he will need reasonable accommodation to perform the job. Carl replies that he will need accommodation. The employer asks Carl for examples of accommodation, and Carl suggests two possibilities: a stool so that he can sit down but still reach the conveyor belt, or a sit-stand chair, which will provide support and enable him to do the job. So this fact sheet here has some questions and answers and examples like that. Okay, since we're running out of time, we're wrapping up here, but I'll fly through the end of this. If you need some additional help, look at your employee manual or talk to your union rep if you're a member of a union. And then let's look at a case study here. If Sarah is a part-time employee, has worked for a place for 2 months, and it's a big employer of 200 employees, would she qualify for ADA protection if she had a cancer diagnosis and would need some flexibility to be able to get treatment? I'll let you think about that. Oh. So yes, the ADA likely applies because she works for an employer of 15 or more employees. The 2 month thing was a trick question because under the ADA, you can even be an interviewee or an employee. You don't have to have worked there for a certain number of months or years to be qualified. So yeah, the ADA likely applies. She might need to ask for reasonable accommodation to help her do her job, or she might need time off. So lastly, one practical tip is now that you know about the ADA, you know about FMLA, you know the decision whether to disclose your disability is completely up to you and depends on whether you'll need reasonable accommodation or time off. But important to know, if you are a person with a disability, even if you're qualified for protection under the ADA or state fair employment law, you can still be terminated for performance-related reasons. So if you're not showing up to work, or you're falling asleep on the job, or your performance is suffering because you have to meet certain numbers and you're not meeting those numbers, you can still be negatively punished or terminated if your performance is suffering, if you haven't disclosed the need for accommodation at your work. So sometimes what happens is people are terminated and then they say, wait, boss, but I have cancer. That's why I was falling asleep. I was just, having a hard time. You have to ask for accommodations before your work suffers, because your performance can still lead to being terminated. Having a disability does not mean automatic protection and that you can't be fired for any reason. You can still be terminated, and that often surprises people. But so just make sure that if you have a disability, you don't want to tell your employer, just remember that after you're terminated, there's no protection. You have to ask for accommodations before your work is going to be affected. So if you think you might be falling asleep on the job, you could ask your employer to take breaks every so often to go outside and get some fresh air or walk around, or whatever accommodations you need to help you not have your performance suffer at work, so that you're not terminated for performance-related reasons. Okay, so the Americans with Disabilities Act protects you against discrimination. Doesn't give you unlimited protection, but if you suspect discrimination, the EEOC, that's who you file your complaint with. And then if you need accommodations on the job to help you come up with an accommodation, the Job Accommodation Network is great, so is Cancer and Careers. And then the Department of Justice, the ADA webpage that has some good resources too. Lastly, one other resource is the Cancer Legal Resources website. Visit our website for the reasonable accommodations template. And if anyone has any questions, thank you for attending. We've come to exactly almost 1 o'clock. I'll stay on a few more minutes. If someone has questions, I can answer those. And I'll be here online for a little bit of time. Someone asked the question where to find more information for help after unfair termination. Yeah, if you think you were unfairly terminated, you can contact us, fill out an intake. I didn't put our intake website, but it's clrcintake.org. I'll leave that right here. You can fill out an intake on this website. Let us know the size of your employer, the circumstances under which you were terminated, and we can help you provide some information for your situation. And then if you want to report an employer who you think was behaving wrongfully, discriminatorily, you can make that report under the EEOC, which is here. their website will direct you to where to go for filing a claim of wrongful termination. So hopefully that answers your question.